4 days after I delivered my baby girl by emergency C-section, my mother-in-law walked into my hospital room with my husband's pregnant assistant and a manila envelope thick enough to choke a horse. She didn't even wait for the nurse to leave. She just set the envelope on my tray table, right next to my untouched lunch, and said, $18 million, Claire. Sign the papers. Leave tonight. The baby stays with her real family. I remember the exact sound the IV machine made in that moment. A soft, rhythmic beep, like it was counting down to something. My daughter was asleep in the bassinet beside me, 3 days old, with a little pink knit cap the nurse had put on her that morning. Her name was Amelia. I had picked it out 7 months earlier, lying on the bathroom floor of our Boston brownstone, watching my husband David cry tears of joy when I showed him the ultrasound. Now David was standing in the doorway behind his mother, not looking at me, one hand resting on the small of his assistant's back. Her name was Brielle. She was 24, blonde, and about 4 months along. I had met her exactly twice at company Christmas parties. Now she was wearing my husband's wedding gift to me, the sapphire pendant he'd said was one of a kind. I looked down at the envelope. My mother-in-law, whose name was Margaret, smiled at me, with that thin, lipstick smile she used when she was about to carve someone apart. "It's a cashier's check," she said. "Non-negotiable. You sign the divorce papers, you sign the custody waiver, and you disappear." My granddaughter deserves to grow up in the Whitmore home, with Whitmore values. Not with a girl whose mother worked double shifts at a diner in Lowell. She said Lowell like it was a disease. I want to stop here and tell you something important about me, because it matters for what comes next. My name is Claire Donovan. At the time this happened, I was 29 years old. I had grown up poor, worked my way through Boston College on scholarship and 2 jobs, and by the time I met David Whitmore at a nonprofit gala when I was 26, I had been a senior quantitative analyst at one of the largest insurance firms on the East Coast for 3 years. I specialized in reading the actuarial language that goes into trust instruments, estate structures, and the dense, boring legal documents that wealthy families use to protect their money across generations. David and his mother had no idea what I actually did for a living. When David introduced me to his family, Margaret had asked me what I did, and David had answered for me. "Claire works in finance, Mother. Nothing that would interest you." He had laughed. Margaret had laughed. I had smiled and sipped my wine and said nothing, because even then, 3 years before my wedding, I knew something was off about this family. I just didn't know yet how off. So there I was, 4 days after a C-section, sitting in a hospital bed with $18 million in front of me, and a baby sleeping 6 feet away. "I'd like to speak to my husband alone," I said. Margaret laughed. Not a polite laugh. A sharp, amused one. "Oh, darling, you're not speaking to anyone alone. You're signing. Or we go to court, and I promise you, no judge in Massachusetts is going to give custody to a girl who tried to blackmail her in-laws with a sob story about a diner waitress mother." I looked at David. "Do you have anything to say?" David finally looked up. His eyes were wet, but not from remorse, from cowardice. "Claire, please, just take the money. Brielle is pregnant with my son. Our family needs to start fresh. You'll be taken care of. 18 million is more than generous." I sat very still. Then I said, "Can I have a pen?" Margaret reached into her Birkin and handed me a gold Mont Blanc. She was practically purring. Brielle kept one hand on her stomach, the other laced with David's. Nobody looked at Amelia. Not once. Not even my husband. I opened the envelope. The check was inside, printed on heavy bonded paper. $18 million, made out to Claire Whitmore, drawn on Margaret's personal trust account. Behind it were the divorce papers, the custody surrender, and a non-disclosure agreement that said I could never contact the child, the father, or any member of the Whitmore family for the rest of my natural life. I read every page. Slowly. Margaret started tapping her foot. David cleared his throat. Then I signed. Claire Whitmore, in perfect looping script, on every line. Margaret let out a long breath. "Good girl. I knew you'd be reasonable." The driver is waiting downstairs. He'll take you wherever you like. Your personal items have already been removed from the house." I handed her the envelope back. I folded the check carefully and put it inside the zipped pocket of the hospital robe they'd given me. My hands did not shake. "The discharge nurse comes at 6, I said. "I'll leave at 6. Brielle smiled. Actually smiled. "It's really better this way," she said. Her voice was soft, almost kind, like she thought she was doing me a favor. "David and I have been together since before you got pregnant. We just needed this to be clean." My mother-in-law leaned over the bassinet for the first time, looked down at Amelia, said, "She has his nose, thank God." Then the three of them left. I waited until the door clicked shut. I waited until I heard the elevator ding down the hall. Then I picked up the hospital phone and dialed a number I had memorized 5 years earlier, the number of a man named Terence Bellamy, who was my oldest friend, my college study partner, and the managing partner of a boutique law firm in Cambridge that specialized in trust and estate litigation. Terence had been the best man at my wedding. He had also been the one person, 18 months earlier, who had looked at me over dinner and said, quietly, "Claire, I don't trust your husband. I don't trust his mother. Please, protect yourself." I had listened to him. That was the thing. I had listened. "Terence," I said when he picked up. It happened. There was a pause. Then he said, "Where are you?" "Brigham and Women's. Room 412. I have about 90 minutes before I discharge. I'll be there in 40. At 6:15 that evening, I walked out of the hospital with Amelia asleep in a car seat. Not in the Whitmore family SUV. Not with the driver Margaret had arranged. I walked out through the staff exit with Terence, got into his Prius, and drove directly to a short-term rental on Beacon Hill that I had secured under an LLC I had formed 4 months earlier, during my second trimester. Because here is what Margaret didn't know, what David didn't know, what Brielle, who had been sleeping with my husband for 16 months, also didn't know. I had been building this exit for almost a year. It started at my 7-week OB appointment. David hadn't come. He'd texted me a sad face emoji and said he was stuck in a meeting. On my drive home, I stopped at a red light on Boylston and watched my husband walk out of a restaurant with his hand on Brielle's lower back, the same way he'd done 1,000 times with me. I didn't honk. I didn't roll down the window. I just drove home, sat in our kitchen, and made a decision that took about 45 seconds. I was going to have this baby. I was going to protect this baby. And if my husband and his mother were going to betray me, they were going to do it against a prepared woman. Over the next 8 months, while smiling through baby showers and prenatal yoga, I did 3 things. First, I quietly moved every asset of mine into a trust in my daughter's name, structured through a Delaware entity that required 2 signatures to access, mine and Terence's. My pre-marriage savings, my stock options, my inheritance from my grandmother, all of it. Second, I pulled the Whitmore family trust documents. This was the part Margaret should have thought about, because my actual profession, the one David had laughed off at that first dinner, was to read trust instruments for a living. And Margaret's family trust, established by her father in 1984, had a clause in Section 7 that she had either forgotten or never read. The clause stated that the primary beneficiary, which was Margaret, retained her income distributions only so long as the family name continued through her direct descendants. Divorce of a Whitmore heir without issue triggered a review. Abandonment of a Whitmore grandchild triggered a reallocation to collateral branches of the family, specifically to Margaret's estranged younger sister, a woman named Patricia, who lived in Santa Fe and had been cut off 30 years earlier after marrying a schoolteacher. In other words, if Margaret successfully paid me to abandon my daughter, Margaret would lose her own trust distributions. But there was more. Because David and Brielle had bragged, publicly, at 2 company events I had attended, that Brielle was pregnant with David's son, and then a medical record had surfaced in David's desk drawer 2 months before my delivery, when I was home alone looking for a tax document, a fertility clinic evaluation from 3 years ago. David had 0 motile sperm. He was, clinically, incapable of fathering a child, which meant one of two things. Either Brielle's baby wasn't David's, which would be a problem for her, or David had a secret I didn't want to know. Either way, it meant that if the Whitmore family trust ever required proof of biological descent, which it did, Brielle's child would fail the test. And Amelia, my Amelia, who had been conceived through IVF using an anonymous donor, a procedure David had begged me to keep secret from his mother, was the only legitimate Whitmore grandchild that would ever exist. Margaret had just paid $18 million to eliminate the one child who could preserve her trust income. Third, and this was the part Terrence had helped me with most, I had prepared an evidence file. Emails. Photos. A forensic accountant's report on David's offshore accounts, which had been drained of $3.4 million over the previous 14 months, presumably to keep Brielle comfortable. Hotel receipts. Text messages David had never bothered to delete. And a full paper trail of Margaret's financial pressure on David to produce an heir, which she had been doing aggressively for 3 years because her own trust terms required it. By the time Margaret woke up the morning after I disappeared, I was 3 steps ahead of her. And that is when she started to panic. The first call came at 9:47 a.m. It was David. His voice was different, cracking. "Claire, where are you? My mother is losing her mind. The check hasn't cleared." "Why hasn't the check cleared?" "Because I had deposited it at 7:03 that morning into an escrow account held by Terrence's firm, with a note that the funds would be held pending review of the enforceability of the documents I had signed. Specifically, the non-disclosure agreement, which under Massachusetts case law could not override a parent's right to speak publicly about matters affecting their minor child. And the custody surrender, which had been executed in a hospital room 4 days postpartum, while I was still on post-surgical pain medication, which made it voidable under state law regardless of what I had signed. None of this surrender was real. It couldn't be. Margaret had known that. She had just assumed I would be too broken, too isolated, too scared to fight back. I did not answer David's call. The second call came at 10:15. Margaret. I did not answer. The third call came at 11:02. Also Margaret. A voicemail this time. I listened to it. Her voice was shaking. "Claire, we need to talk. There has been a misunderstanding. If you return to the house, we can work something out. Something better than 18 million. There is no need for this to become ugly." I deleted it. At noon, Terrence filed papers at Suffolk County Probate and Family Court. An emergency motion to void the custody surrender, a petition for divorce on grounds of adultery, with documented evidence, a motion for sole legal and physical custody of our daughter, and a motion for equitable distribution of marital assets that included a request for forensic discovery of the Whitmore family trust. That last part, that was the one that made Margaret scream. Because Massachusetts law allows a divorcing spouse to investigate any trust in which the other spouse has a contingent or discretionary beneficial interest. And David was a contingent beneficiary of his mother's trust, which meant my divorce attorney was about to legally and publicly open every page of the Whitmore family trust in open court, which would reveal the paternity clause, which would reveal that Brielle's child, if she was claiming it was David's, was either not David's, or was the result of something David had lied about to his mother for his entire adult life. Margaret called the 14th time at 3:45. I answered. "Claire." Her voice was different now. Soft. Almost gentle. The voice I recognized from the first time I met her, when she had wanted to charm me. "Claire, darling. Let's not do this. Let's sit down, woman to woman. I was wrong. I was wrong, Claire. Come home. Bring Amelia home. We can start over." I sat in the nursery of the rental, watching my daughter sleep in a bassinet that I had bought and assembled myself at 36 weeks pregnant. "Margaret," I said, "I know about Section 7. There was silence. A long, suffocating silence. "I know about David's medical records. I know about the 3.4 million. I know that Brielle's baby cannot be David's, because David cannot father a child, and I know that if you try to present that baby to the trustees as a Whitmore heir, My attorney has already prepared a sealed disclosure that will be unsealed the moment you contest my daughter's custody or her inheritance. Amelia is the only biological grandchild you will ever have, because Amelia is mine. I conceived her with a donor. David agreed. He signed the IVF consent forms, which means the trust distribution you have been collecting for 30 years, Margaret, depends entirely on whether I choose to put my daughter's name on your family tree. The silence stretched. Then Margaret said, very quietly, "What do you want?" I had prepared this answer. I had written it down and rewritten it and memorized it, because I knew this call was coming. I want sole custody. I want Amelia's name legally changed to Donovan. I want David's parental rights terminated in exchange for me not pursuing criminal charges for the custody surrender, which, as you know, was obtained through duress. I want the $3.4 million returned to the marital estate and added to my settlement. I want the Beacon Hill brownstone signed over to me, free and clear. I want a structured annuity in Amelia's name, funded by your trust of $4 million, paid out over her lifetime, that does not require her to ever acknowledge the Whitmore name. And I want you, Margaret, to sign a statement acknowledging that you offered me $18 million to abandon my newborn daughter, which will be held in escrow and used only if you ever attempt to contact Amelia, me, or any member of my family for the rest of your life. She was quiet for a long time. And the trust? She said. Section 7? Amelia stays the heir on paper. You keep your income, as long as you stay away from her. I heard her breathing. Slow, controlled. The breathing of a woman who was realizing she had built a trap and walked into it herself. Fine, she said. Have your lawyer send the papers. We hung up. I sat in that nursery for a long time after, listening to Amelia's soft baby sounds and feeling something I had not expected to feel. Not triumph, not rage. Just a kind of cold, steady calm, like I had walked through a fire and come out on the other side, and the world was quiet now. The papers were signed within 3 weeks. David tried to fight me on the custody termination. It lasted 2 court appearances. The third appearance, his own attorney quit after being shown the fertility records. David signed the termination the next morning. He sends a card to an address he thinks is mine every year on Amelia's birthday. It goes to a P.O. box Terrence monitors. I throw them away without reading them. Brielle had the baby. It was a girl. The father, as it turned out, was David's business partner, a man 20 years older than David, which was the secret David had been covering for her. When the Whitmore Family Trust held its annual review that fall, the trustees required DNA confirmation of any new Whitmore descendant. Brielle refused. The trustees ruled that her daughter was not a qualified heir. David and Brielle broke up 4 months later. Brielle is now suing David's business partner for child support. Margaret pretends none of it is happening. Margaret herself is still alive. She lives in the same Brookline mansion where I once spent a very uncomfortable Thanksgiving. She has not seen her granddaughter in more than 3 years. She has not tried. She knows what happens if she tries. Every month, on the 1st, she signs a trust distribution check that goes into Amelia's annuity. I have a photograph that Terrence sent me once of Margaret at a charity event, wearing her pearls and smiling at a camera, and her eyes in that photograph are the emptiest thing I have ever seen. I moved out of Boston 18 months ago. Amelia and I live in a small town on the coast of Maine, in a cedar-shingled house with a garden I planted myself. I work remotely now, consulting on trust and estate matters for women going through exactly what I went through, women who married into wealth and are trying to figure out how to protect themselves and their children. I run a small foundation that funds legal aid for mothers facing custody pressure and divorce. We have helped 92 women in our first year. Amelia is 3.5. She has red hair, which is mine, and a laugh that sounds like a wind chime. She does not know any of this story. She will, one day. When she is old enough, I will tell her every word of it. I will tell her that the woman who was supposed to love her the most tried to buy her like a piece of furniture. I will tell her that her mother walked into a hospital room with nothing and walked out 4 days later with a plan. I will tell her that the money was never the point, that the point was her, and that every woman should know her own worth is not something another person gets to price. People ask me sometimes, when I speak at conferences, or when a woman I am helping asks in the quiet of a phone call, how I did it, how I stayed calm in that hospital room, how I signed those papers without my hands shaking. I tell them the truth. I tell them that my mother, the diner waitress from Lowell, worked double shifts my entire childhood. She raised 3 children alone after my father left. She put me through the first 2 years of college on tips and grit. She died of ovarian cancer when I was 23, 6 years before I ever met David Whitmore. The last thing she said to me, in a hospice room in a hospital not unlike the one where Amelia was born, was this: "Claire, don't ever let anyone put a number on you, and don't ever, ever let anyone put a number on your babies." I was 23. I thought it was just something a dying mother says. 6 years later, in room 412 at Brigham and Women's, with an envelope full of cash and my daughter asleep 6 feet away, I understood exactly what she had meant. And I kept my promise.